Welcome to today's episode from Siam Center Law Group Podcast. And in today's discussion, we will delve into the important topic of inheritance and wills in Thailand, particularly focusing on the challenges that arise when elderly individuals pass away without leaving a will. As Thailand enters an era with a growing elderly population, the issue of property problems upon the demise of individuals who haven't made a will has become increasingly common. In Thai law, when a person passes away, their inheritance is transferred to their heirs, who assume both the rights and obligations associated with the inheritance. In Thailand, there are two types of heirs: statutory heirs and heirs by will. Heirs by will are individuals who have valid evidence of a will. Under Thai law, there are 5 types of wills that can be recognized. The first type is a simple will, which is a basic and straightforward document expressing the testator's intentions regarding their assets. The second type is a fully written will, which must be handwritten by the testator themselves to be considered valid. The third type is the city will, which must be made in the presence of local officials who can provide proper documentation. The fourth type is a secret will, where the testator seals the will before handing it over to an official who signs the seal, keeping the will securely. The fifth type is the verbal will, which is rarely used in modern times and typically reserved for specific circumstances, such as severe epidemics or wartime situations, allowing for an oral declaration of the testator's wishes. It's important to note that the amount of property one possesses is not a determining factor for making a will in Thailand. Even owning just one asset, such as a motorcycle or a car, is sufficient grounds for making a will. However, it is crucial to carefully consider the implications of a will that bequeaths all assets to one person, as this action will effectively disinherit the statutory heirs. Therefore, thoughtful consideration is necessary before deciding who will inherit the property. In practical situations, disputes may arise among heirs when they question the testator's mental capacity at the time of making the will. To address this issue, if the testator is in a critical condition at a hospital, it is advisable to have witnesses present during the will-making process. These witnesses could include a lawyer, a nurse, or a doctor. It is also recommended to obtain a medical certificate confirming that the testator had full consciousness at the time of making the will. Although not required by law, having such a medical certificate can help prevent later disputes regarding the testator's mental state during the will-making process. By taking these precautions, individuals can ensure that their wills are valid and that their intentions regarding the distribution of their assets are properly documented and understood. Thank you for tuning in to today's episode. If you have any further questions or require legal assistance regarding inheritance and wills, please don't hesitate to contact us. We're here to provide guidance and support. This concludes our discussion for today. Stay tuned for future episodes where we will explore more legal topics relevant to Thailand. Remember, understanding the law is crucial for protecting your rights and making informed decisions.